We want to welcome to the School of Tyrannus Andy Woods, who has an interesting background. He is a lawyer. He's been through law school, bar exam, practices as a lawyer in California, and then began to get interested in theology and decided that the Lord wanted him to become a minister, a pastor, and he needed training, new training now, in theology, and came to seminary. And Andy, we're delighted to have you with us on our School of Tyrannus internet program, and want to get acquainted with you. Tell us, I understand you have an interesting viewpoint on the legal system, that it has been impacted by the theory of evolution.
Yeah.
How does that work?
Well, it's a very interesting idea relating to how judges in our day approach our Constitution. And first of all, we got to kind of spell out what evolution is. Evolution is not just a biological concept. It's a worldview. Mm-hmm. And basically what it teaches that as we evolved from the lower species, that even today we continue to evolve, which is the opposite of what Romans 1 says. But what evolution is teaching is that we're on an upward ascent.
So evolution is impacting all areas of our life.
Yeah, it's a worldview. Mm-hmm. And Darwin's Origin of Species came out in about 1859, I think it was. And about 11 years later, 1870 would be the crucial year here. We see a shift in how constitutional interpretation is approached in the law schools. And the idea is that if man is evolving upward, as the theory of evolution says, then we also need a document that evolves upward as well. And so the function of the judge now is not so much to go back to the original intent of the founders, but is to watch society. Watch where society is moving, headed, and then reinterpret the document to keep up with where society is ascending upward. So that would be the connection between the two.
So the guide is not the Constitution, but current societal mores and attitudes.
Yeah, and that's the fundamental shift that we see beginning to take place in the law schools in 1870. There's a movement away from studying the text to studying society. And today in modern legal education, the text receives very little emphasis, the text of the Constitution. For example, I went through law school and I took 2 semesters of constitutional law. Mm-hmm. We were never given an exam on the United States Constitution. We were never required to read the United States Constitution. I never received a lecture on the United States Constitution. I don't recall seeing too many questions on the actual text of the Constitution on the bar exam. What I remember are case holdings and case law. And that's where our attention was spent.
Well, now, some of our viewers might be interested in knowing, what is case law? How is that different from the Constitution?
Yeah, case law is just the latest decision with respect to how judges have interpreted the Constitution. So if the Constitution is evolving upward, and the function of a judge is to continue to evolve the document upward, then what's really important in our legal system is the latest opinion.
I've been told by some attorney acquaintances that, speaking to me, they say, well, you can't really know what the Constitution says. It's not what you think it says, it's what the court says it says.
Yeah.
And that's in the same line there.
That's the same line of thought. There's a famous quote which a legal positive says, the Constitution says what the judge says it is. And this has really interestingly taken over legal education. And as I said before, you spend most of your time in law school studying the latest opinion. It would be like Dr. McCall if you went to seminary and and you spent no time in the text of the Bible, and you spent all your time studying what commentators have said about the Bible rather than what the Bible itself actually says.
Well, it's sad to say that is what happens in a lot of seminary studies. They never get near the text of the Bible, and they're just looking at various explanations of who wrote this part and who wrote that part, and commentaries explaining this and that and the other. They never get in the text as well, and that's a sad thing. But it is an interesting parallel. But now when the writers of the Constitution wrote it, what was their intention? How is what is happening now? Does this follow along with what they intended, or is it different?
It's night and day in terms of difference, and we can show this in several ways. One is to go back to Federalist Paper number 78, and you remember the Federalist Papers,
Yep.
And those were intended to communicate the intent of the document to those who were going to ratify it. And
This was before it was actually ratified.
Exactly.
While the debate was going on
Exactly.
about accepting the Constitution.
And Federalist Paper number 78 calls the judicial branch of government the least dangerous branch of government. In other words, the Founding Fathers were saying to the potential ratifiers, don't worry about the judicial branch, they don't have any power. Well, today, because of this hermeneutical shift that we've been talking about, the judges have all of the power. And as a result, they have a capacity to read into the document very controversial ideas, things that aren't there. And when we, as the good citizens of the United States of America, don't like it, we have no capacity to vote them out of power, because they, at the federal level at least, are appointed for life. Let me just give you one quick example, is the infamous Roe versus Wade decision. Now, this is one of the most controversial decisions that's ever come down. It's an issue which divides the American people. So the question is, whoever voted on that? How did this come into the fabric of our society? That was imposed upon us through the unelected. And when the good folks of the United States of America may not like that decision, you can't vote it out, you're stuck with it. And so that's the drift in terms of getting away from the Founders' vision.
Well, you mentioned that the Founders considered the courts relatively impotent and not powerful. Why would they think that? Why would they think that the courts wouldn't have much power? It was because they didn't have any armies, or anything. What was the reason?
Yeah, the reason is there was an assumption that judges would follow the text. And you find this at many places. For example, if you go back and read the great commentaries on the Constitution by Justice Joseph Story, who wrote these very influential documents, he says over and over again that the text is to be approached in its very plain sense. Matter of fact, if you read what Justice Story said, you would think you're reading something by Charles Ryrie in terms of hermeneutics, or Bernard Graham in terms of hermeneutics. And so it was just an assumption that they would approach the text in its original intent. This idea that you could move away from the author's intent was just an idea that was foreign to the Founding Fathers.
Well, these comparisons with theology are interesting, and hermeneutics, interpreting the Bible, are interesting because we're told that there's exegesis and there's eisegesis. And, exegesis is trying to find out what the text actually says and applying it and understanding it. Eisegesis is reading into the text what we want to read into it. Now, is that what the judges are doing with the text of the Constitution?
When you go back to the original vision, it was assumed that there would be pure exegesis. Today, because it's viewed as a living document, which the judge changes from one generation to the next, they have read into the document ideas that aren't there. I would challenge anybody reading the Constitution to find the words privacy, to find the word abortion. Matter of fact, you know where that came from? They said when that decision was handed down, that comes from the penumbras. You say, well, what's a penumbra? A penumbra is a shadow. In other words, when you look at certain constitutional principles that cast this shadow, and it was out of this, murky shadow that they came up with this so-called right to privacy.
Was it the invasion of one's papers or something like that? is that in the Fourth Amendment or something like that, that had the penumbra, then you got to accord a privacy to women who are pregnant or something like that?
Yeah, that kind of idea.
Mm-hmm. Well, you mentioned the term legal positivism, and I'm sure most of our viewers are not familiar with that terminology. What does that mean?
Yeah. The Constitution has a mechanism in it to change it, and that's the amendment process. And that places the power to change the document in the people's hands, the representatives. In other words, if the document's being changed in a way people don't like, they can vote against it. The legal positivism is a school of thought which says, we, the judge, are going to change the document. We're going to follow where society is headed in terms of its evolutionary progress and continue to reinterpret the document. And so what they're doing is they're circumventing the amendment process. They're getting around it.
Would this be the same as activism? Is positivism identical to what we hear about legal activists? Are they the same as legal positivism? Sure.
Positive law and judicial activism are the same synonymous ideas.
And this is all, again, a response to the worldview of evolution that sees society and laws and everything evolving upward.
And this isn't my original idea. I studied a constitutional scholar by the name of John Eidsmoe, who's a committed Christian, and he's the one that first introduced me to this idea. And in his books, he cites evolutionary language that judges use. In other words, there's this unwritten assumption that things are evolving. And so we need to evolve the document as well. And as I said before, Darwin's Origin of the Species was first published in 1859. And then just 11 years later, in 1870, through some teachers at Harvard Law School, Columbus Langdell and Roscoe Pound, people like that, operating off an evolutionary worldview, brought in this new method of interpretation. So I think there is a certain connection between the two.
Was there any reaction against this at the time?
No, not that I am aware of. It wasn't until it continued to be pushed and the Supreme Court got more and more power that this became very controversial during the nomination process of Robert Bork. The liberals understood that if Robert Bork got on the court, all of the social policies that they've been able to push on the American people through the unelected judiciary, Bork would have gotten rid of a lot of that because he wanted to go back to the original intent. And that's why this confirmation process has been so controversial.
Well, he was Bork.
He was Bork. We even have a new name that we use because of what would happen to that poor man.
Yes. Well, I understand that there's a clause in the Constitution that's rarely referred to, but it gives Congress the power to restrict the matters that the courts can consider.
Yes.
And there's some movement going on to pass certain laws to that effect. Do you think they have a chance? Is this a good idea? Will it succeed? What would happen with that?
Well, I think it's a terrific idea. Whether it succeeds or not, I don't know if our Congress has the willpower to pull it off. But I think really the root of the problem is the culture in the law schools. Because it's the law schools that influence our future judges. And I think it was one of our...
And congressmen.
And congressmen. The philosophy of government... Excuse me, let me rephrase that. The philosophy of education in the little red schoolhouse in one generation will be the philosophy of government in the next generation. And so I think if we really want to change it, what you're suggesting is a good idea. But ultimately we've got to start new law schools, like what Jerry Falwell and Pat Robertson and people like that are doing, to begin to educate people the way law was originally designed to be taught.
Well, if Congress had the will to pass such restrictive laws, what happened in the courts? Would they accept that? Or would they reinterpret the laws in a way that would undermine that.
This is the ugly situation that we find ourselves in. I don't think they would reinterpret it immediately. What worries me is the next generation and the generation after that. And so we really need to cut off legal positivism at a philosophical level.
Back at the teaching level.
At the teaching level,
Is there any hope for that?
Not given the current climate of most law schools. But if we start some new ones, and I mentioned a couple of gentlemen that are trying to making efforts in that regard, I think we might, in a generation or two, have some time.
Well, Andy Woods has introduced us to a whole new realm of thinking about our legal system, the way that the theory of evolution has impacted it, and how it corresponds to what is happening with the interpretation of the scriptures. And a very interesting and enlightening discussion. And thank you so much for being with us.
Thanks for having me. Appreciate it.